What if the house you finally paid off is the one thing that makes you a target? You worked 30 years to clear that mortgage. Nobody warned you that the day it became debt-free was also the day it became interesting to people you'll never meet. Before we go further, do me one favor. Tap that like button right now, not because I asked nicely, but because this algorithm decides who else gets shown this video, and somewhere out there is a person exactly like you who needs to hear this before it's too late for them. Subscribe if you want the rest of this series, and send this to the one person in your life who still keeps important paperwork in a drawer marked "Sort Later." That drawer has cost people more than they know. Here's the truth nobody puts on a leaflet. Your home is probably the most exposed thing you own, not your savings account, not your pension, your house. Anyone, anywhere can look up your address tonight and find out who owns it, what it's worth, and whether there's still a mortgage sitting on it. If the answer is no mortgage, you've just become one of the more attractive properties on your street to a very specific kind of criminal. That's not a scare tactic. That's just how the system is built. I've spent years working alongside people in financial guidance roles, sitting in rooms with retirees who did everything by the book. They saved, they paid things off early, they avoided debt like the plague. And then, out of nowhere, something happened that could have been stopped with one form, one phone call, or one conversation with a solicitor that nobody ever suggested they have. This isn't about fear, it's about 5 documents that almost nobody over 60 has ever been told to get. Some take 10 minutes, some take an afternoon. None of them are complicated once you understand why they exist. Let's go through them properly, one at a time, starting with the 2 that protect against something most people don't even know is possible. Your property sits inside a national register. It is not a locked filing cabinet somewhere in a government basement. It's a live, constantly updating digital system, and applications can be submitted to change who owns a property, without that property's owner ever being contacted first. Read that again. A change of ownership can be lodged against your home, and the system's normal process does not require anyone to ring you up and check it's really you. This is the engine behind property fraud in Britain. It doesn't look dramatic. There's no broken window, no late-night intruder. It looks like paperwork. A criminal searches public property records for a home with no mortgage and an owner who might be older. That search is legal, free, and takes less time than making a cup of tea. From there, they build a forged identity, create fake transfer documents, and submit an application to move ownership of your home into someone else's name. If nobody catches it in time, the property can be sold before you even know there was a problem. Land Registry processes millions of applications every single year, and in one recent 12-month period, they stopped fraudulent attempts targeting tens of millions of pounds worth of property. The fraud rate sounds tiny when you look at the percentage, but percentages don't comfort the person whose house it actually happens to. There's a free tool that closes most of this risk, and it takes about 10 minutes to set up. It's called Property Alert, and it's run directly by Land Registry, not by some private company trying to sell you insurance. You create an account, add your address or your title number, and from that point on, every time something significant is registered against your home, a new mortgage, a change of ownership, an application of any serious kind, you get an email immediately. You can monitor several properties at once, and you don't even need to be the legal owner to add a property. This means adult children can set it up to watch a parent's home, even if the parent never gets around to doing it themselves. I want to be clear about what this tool actually does. It doesn't block anything automatically. It's a tripwire, not a lock. But a tripwire is exactly what you need because the moment you get that alert, if it's not something you recognize, you call Land Registry's fraud team straight away and tell them clearly that you did not authorize this application. They can pause it while they investigate. Speed is everything here. The faster you report it, the easier it is to stop. Set this up today. Free, fast, and it could be the single most useful 10 minutes you spend this year. There's a second layer that goes even further, and it's worth knowing about even if it's not for everyone. It's called a restriction, and the most relevant version for homeowners is known by its form code, RX1, which places what's commonly referred to as an LL restriction on the title. Once this is in place, nobody can sell, remortgage, or transfer your property unless a solicitor personally confirms, in writing, under their own professional name, that the person signing the paperwork is genuinely the registered owner. Not a junior staff member, not an email confirmation, the actual solicitor verifying identity properly. Why does that matter so much? Because almost every property fraud case relies on one simple trick, convincing a system that a fraudster is actually you. A restriction like this forces the criminal to deceive a regulated professional face-to-face, which is dramatically harder than forging a signature on a form. Not everybody needs this. If you live in your home full-time and nothing unusual is going on, the free alert may genuinely be enough protection. But if you're a landlord, if you travel a lot, or if you're an older homeowner living alone in a property with no mortgage, this extra step is worth a conversation with a solicitor. There's a small fee involved, and it's worth knowing the same solicitor will likely need to confirm your identity again when you eventually sell or remortgage. It's a small inconvenience for a much harder wall to climb over. Now here's where this story takes a different turn, because the next document has nothing to do with criminals at all. It's about what happens inside your own family if something sudden takes away your ability to make decisions. Most people assume that if their husband, wife, or partner had a stroke, a serious fall, or a diagnosis like dementia, the other person could simply step in and manage things. Pay the bills, deal with the bank, handle the house. It feels obvious. It feels like common sense. It is not how the law actually works. Without a specific legal document in place, even a spouse cannot automatically access accounts, sell property, or make financial decisions on someone else's behalf. Marriage does not grant that authority. Neither does being a parent or a child. The document that grants it is called a lasting power of attorney for property and financial affairs. It lets you choose, while you're well and thinking clearly, exactly who should be allowed to step in if you ever can't manage things yourself. You register it with the Office of the Public Guardian, and the registration fee is currently under £100. Most people set up two at once, one covering property and money, and a separate one covering health and welfare decisions, so the combined cost usually lands under £200 total. If your income is low or you receive certain benefits, you may pay significantly less or nothing at all. Compare that to the alternative, which is what happens if nobody has one of these in place and a family suddenly needs legal authority over a loved one's affairs. That route goes through the Court of Protection, and it is slow. The application fee alone runs into hundreds of pounds, with ongoing supervision costs after that, and the process can take 4 to 6 months before anyone has legal authority to act. 4 to 6 months where bills might go unpaid, where a property can't be managed, where decisions simply freeze in place. I think about a man I'll call Robert. 68 years old, married for over 40 years. His wife had managed their household finances, their entire marriage, every account, every bill, every policy. Then she had a sudden stroke. Robert genuinely did not know who their energy supplier was. He didn't know which accounts held their savings. He didn't know where the insurance documents were kept. And because there was no lasting power of attorney in place, he had no legal right to access any of it, even though he was her husband, even though he was desperately trying to hold their life together while she was in hospital. They had wills, carefully written, properly drafted wills. But a will only matters after someone dies. It does nothing while someone is alive but unable to manage their own affairs. Robert spent months navigating a legal maze that 10 minutes of paperwork, years earlier, would have completely avoided. When he finally understood what had happened, his first question was simple. Why did nobody tell us this before we needed it? That's the entire point of this document. You cannot set it up after a crisis begins. Once someone's mental capacity is genuinely in question, it may be legally too late to create one at all. It has to be done while you're capable of understanding what you're signing. Do it now while it feels unnecessary, because that's the only time you're allowed to do it. Alright, pause for a second. If this is landing with you, hit subscribe before you forget, because the next two documents are the ones that genuinely shocked me when I first understood them properly, and I don't want you to miss where this goes. Drop a comment with just the number of the documents so far that surprised you most. I read every single one. Most couples in England and Wales own their home in a way called joint tenancy, and almost nobody chose that on purpose. It's simply the default. Under joint tenancy, when one partner dies, the entire property automatically passes to the surviving partner. Not through the will, not through any decision made at that moment. It happens instantly, by law, regardless of what either of your wills actually say. The house transfers by survivorship before the will is even read. Here's why that matters so much. Once the surviving partner owns the whole property outright in their sole name, and if they later need residential care, perhaps after a fall, perhaps after a diagnosis, the local authority carries out a financial assessment to decide who pays for that care. In England, the threshold is around £23,000. Above that figure, you are expected to fund your own care completely, and that figure includes the value of your home. Residential care now frequently costs well over £1,000 a week. Do that maths over a few years, and a home worth £250,000 can be entirely consumed by care fees in under 4 years. Everything built across a lifetime, gone, simply because of how the property was legally held. This is the part that genuinely troubles me, because it is completely preventable, and almost nobody knows it in advance. I think of a woman I'll call Eileen, 74, recently widowed. Her husband had spent his final weeks reassuring her that everything was sorted, that the will took care of the children, that she had nothing to worry about. The property was held as joint tenants. By the time Eileen sat down with someone who understood the system, survivorship had already happened automatically. The entire house was now hers alone, and the will, however carefully written, had never even had the chance to operate on that property. Everything he'd built across a lifetime was now fully exposed, sitting there as one single asset in one single name. Two simple legal steps would have changed everything. The first is called a deed of severance. It changes how a couple legally holds their property from joint tenants into something called tenants in common, where each partner owns a clearly defined, separate share rather than the whole thing jointly. This is applied for through land registry and is a relatively straightforward process. The second step is updating both wills to include something called a property protection trust, sometimes referred to as a life interest trust. Here's how it works. When the first partner dies, their share of the house doesn't pass outright to the surviving spouse. Instead, it goes into a trust. The surviving partner still has every practical right to live in the home, to sell it if they choose, to move somewhere else if their needs change. But that share legally belongs to the trust, not to them personally, which means it cannot be counted as their asset if a means test for care fees ever happens. When the surviving partner eventually passes away, the trust ends, and that protected share goes to whoever was originally named, usually the children. I want to be completely honest about the limits of this. It protects the first partner's share after the first death. It does not make the surviving partner's own assets invisible. This is not a magic shield against all care costs. It protects roughly half of the property's value, which, let's be honest, is enormously better than protecting none of it. It does require a solicitor to draft the trust correctly inside the will, because if it's worded poorly, the protection simply doesn't function the way it's supposed to. This is not a do-it-yourself document. Get proper advice, but get it. Now, the fifth document is really two smaller pieces, and one of them surprises almost everyone I mention it to, because most people assume their home is simply untouchable once it's paid off. It is not. Let's start with the easy half. If you are now the only adult living in your home, perhaps after a partner has passed away or moved into care, you're entitled to a 25% discount on your council tax bill. This is not applied automatically, just because your circumstances changed. Councils don't track this for you. You have to ring them and tell them directly. While you're on that call, ask about the council tax reduction scheme as well. It's based on income, administered locally by each council, and in some cases can reduce your bill to almost nothing. The overwhelming majority of people who actually qualify for these reductions never claim them, simply because nobody ever told them to ask. Now for the part that genuinely catches people off guard. A mortgage-free home is not automatically protected from your creditors. People assume that once a property is paid off, it's untouchable, a kind of financial fortress. That's not how the law treats it. If you owe money on something like a credit card or a personal loan, and a creditor takes you to court and wins a county court judgment against you, they can then apply for what's called a charging order. This gets registered directly against your property at land registry. It sits there quietly, attached to your home, and when you eventually sell, the creditor gets paid first, straight out of your equity, before you see a penny of it, the equity you spent decades building. I think of a man I'll call Tom, 66, retired, who had run into some credit card debt during a difficult stretch in his early 60s. A county court judgment had been issued against him, but the original letter notifying him had simply sat unopened on a hallway table for far longer than he'd like to admit. He genuinely had no idea this could happen. A charging order was eventually registered against his home while he was living comfortably inside it, paying his bills every month, assuming that owning the property outright meant it was completely safe. It is not safe just because it's paid off. If you ever receive a court claim form, respond to it immediately. If a county court judgment ever arrives, do not let it sit in a drawer. Reach out to a debt charity or a citizens' advice service that same week, because the longer it sits unanswered, the harder it becomes to stop the consequences. And here's something simple you can do today, regardless of anything else. You can download your own title register from Land Registry's website for a small fee, often just a few pounds, and it will show you exactly what is currently registered against your property, including any charges. It takes minutes, and it tells you the truth about exactly where you stand right now, instead of an assumption. So let's bring all five together, because individually they feel small, but together they form something much bigger. The property alert protects you from fraud for free in about 10 minutes. The restriction adds a second wall for those who need stronger protection. The lasting power of attorney protects your family from a legal freeze if something sudden happens to your health. The deed of severance and property protection trust protect what you've built from being swallowed whole by care costs. And the council tax check, alongside that charging order awareness, protects the everyday financial reality of your home from quietly slipping away through debts you might not even fully remember. These 5 documents come from completely different directions: fraud, incapacity, inheritance, debt. But every single one of them is solving the same underlying problem. A home that took decades to pay off can be lost in months through something that already had a solution sitting right there, untouched, simply because nobody ever explained it clearly enough. If you've made it this far, you've just learned more about protecting your own home than most people ever will. Don't let that knowledge sit unused like that unopened letter on the hallway table. Share this with someone in your life over 60, a parent, an aunt, a neighbor, anyone who paid off their mortgage and quietly assumed that was the end of the story. It almost never is. Like this video so it reaches them too, because the algorithm only spreads what people actually engage with. And this is worth spreading. Start with the free one. The property alert. 10 minutes, no cost, government run, and it closes the door on the most common form of risk facing homeowners exactly like you. Set it up before this video even finishes playing. Everything else, the restriction, the power of attorney, the trust, the council tax call, can follow at whatever pace feels right for you. But please don't let it follow at no pace at all. You came into this video as one of the most exposed homeowners in the country, simply by virtue of having paid off what you own. That fact hasn't changed in the last few minutes. What has changed is that now you know exactly what to do about it. The house is still yours. Make absolutely sure it stays that way.